Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. A little later in the program, we'll be talking about $1 billion and what kind of educational reforms that tax increase is not going to give us. But first, what does, I don't know, Ward Churchill, Balloon Boy's dad, Douglas Bruce, and a bunch of death row inmates and me have in common? It's this one man here, lawyer to the stars, David Lane. David, thank you for joining us.
Thank you, my client.
My client. All right, before we talk about all the other bad clients you have, let's talk about the good client you have here.
Absolutely.
You helped me overturn a really bad law that a lot of people don't even know about, and just a week or two ago had a huge success when a federal judge said that House Bill 1326, passed in '09, was unconstitutional. I want to go over this because this is big, but I don't think it's a little subtle and people don't know it. First of all, we have a petition process here in Colorado, which means idiots like me get to go on the ballot sometimes and ask people questions.
We can have a space alien welcoming committee put on the ballot in Denver if we get enough signatures. Get tax decreases, tax increases, medical marijuana, regular marijuana, no Obamacare, more Obamacare, anything people gather enough signatures on a petition for will hit the ballot under Colorado Constitution.
Right, and for guys like me, I look at things like Tabor and open meetings and term limits. None of these things would be passed by the sitting legislature.
The marijuana initiative
marijuana,
too?
Yeah, but I'm talking about guys like me.
The marijuana initiative.
Later. But a law was passed in '09 that really took away this right of petition. First of all, why is the petition right important?
You know, the Colorado Constitution allows people to gather signatures on petitions and put things on the ballot. That's not a federal right that you have. The U.S. Constitution doesn't allow you to go all over the country, gather enough signatures and put something on a national referendum or a national ballot. But a lot of states allow this, Colorado being one. And the U.S. Supreme Court has said when a state gives you a right to do something, they can't infringe upon that right. And Colorado's Constitution gives us that right. What this law did is it cut back on the ability of people to effectively gather signatures by eliminating the pay-per-signature motivation that keeps signature gatherers out there hustling for signatures. It went to a pay-per-hour scheme where, you know, if you're out there and it's a rainy day and you want to go to Starbucks, you're going to make your hourly, whether you're sitting in Starbucks sipping coffee. Yeah, the gatherer. The person out on the street corner is going to be sitting at Starbucks drinking coffee, making their hourly wage instead of out on the streets hustling for signatures so they can get money.
We call those Democrats.
Well,
yeah. All right, but to back up just a little bit. The reason we have the petition process is often to do what the legislature doesn't want to do. Now, the legislature has always hated the petition process because it reins them in. In some ways that I like with Tabor and term limits. In some ways I despise, like Amendment 23, but it reins them in, and it's a safety valve. Legislators, elected officials, for the most part, hate the petition process.
That's what I've said. Nobody hates direct democracy more than our elected leaders.
Why is that?
They believe that it's a representative form of government that we have, and they are our leaders elected to pass laws. And you know, now we're skipping the middleman when we have the petitioning process going on, and they have a natural aversion to it. They simply have to understand that in Colorado, as is true in California and various other states, it's built into the state constitution, and that's part of the game out there. And
in 2010, I tried to get something on the ballot, and thanks to you and your expertise, I was able to. And I asked the question, can we have some protections against government-run health care from the feds? Should we have a right to health care choice? But I didn't have that much money, and it costs a lot to get something on the ballot. People who say it's too easy to amend the Colorado Constitution have never tried. Now, I'm not a rich guy. I'm not Soros, and I'm not Tim Gill or Phil Anschutz. I can't write a huge check. I was able to raise a few $100,000 to hire a team of professional petition gatherers. This is what they do. Under the new law, however, I couldn't hire them. The firm I was working with couldn't hire them and say, for every petition you get signed, I'll give you $1. They said, the new law said you can't pay people that way. It seemed to me the only reason for that law was to make it more difficult for guys like me, poorer guys, to get something on the ballot.
I agree with that, and I think the beauty of this case also was in part, you know, when you were circulating your petition, you kept saying, David, sign my petition, and I kept saying, hell no, John, I'm not going to sign your petition. I completely disagree with your petition. I won't sign it, but I will continue to fight as hard as I can in federal court to allow you to have the ability to get it signed by like-minded lunatics, and we succeeded.
We succeeded because we got an injunction on this law, at least a temporary injunction. What was the argument for this law? I am convinced, and so are you, the reason it was passed is just to keep petitions from being effective.
Absolutely. They wanted to make it as difficult as possible for people to get enough signatures to ever make the ballot. And paying by the hour was the way to do that, because that jacked the price of a successful petition campaign dramatically. You're going to get far fewer signatures, and your hourly costs are going to go way up. And that was the reason behind the legislation. Their espoused reason was, oh, signature fraud is a huge problem here in Colorado. You know, people are forging signatures on petitions, and these circulators are getting $1 for every forged signature that they forge. They could present no convincing evidence that that was, in fact, a problem. They could present no evidence that there was really any problem with paper signature, and the federal judge saw right through their ploy.
I'll concede there are probably forged signatures on petitions, and I understand that's a crime and it can't be. But the question is, how do you prove that somebody's signature was a bad signature? How do you prove that? I mean, and that's the Secretary of State's job, which is those signatures then go to the Secretary of State. His job, or her job at the time, is to go through and do line item and say, these are accurate, these are not accurate. There's enough signatures to go to the ballot.
Well, and we had testimony from someone in the Secretary of State's office who says, we really don't have the money to do that. The only time we'll do that is if there's a challenge by an opponent of the ballot measure, somebody who didn't want to see your initiative make the ballot,
and there were a lot of them,
would challenge, and then the Secretary of State would do spot checks, random checks, to see if the signatures matched up on voter reg cards and the addresses were correct. And if they had a certain percentage correct, then presumptively you had enough valid signatures. It's called the validity rate. And the Secretary of State really needs to get up to speed in the 21st century. They need to get software that will allow handwriting comparisons between the voter reg cards and the people who sign the petitions. They should be able to have, you know, instant recognition to see whether the addresses match up, things of that nature.
But why was this argument that if we jack up the price of getting signatures, that is, put in these roadblocks, and for me, as a free marketeer, if I'm hiring guys to do a job, I should be free to make that arrangement with them, either if I want to pay them by the hour, if I want to pay them a flat fee, if I want to pay them incrementally, if I want to pay them by the signature. I thought in a free society I had the right to do so, but this bill, 1326, said, no, you don't have the right to have that kind of free association.
Yeah, I mean, I think it's, the state has an interest in the validity of elections. The state has an interest in making sure that there is no voter fraud going on. But that doesn't mean that in order to prevent the possibility of voter fraud, we're going to cut back on the First Amendment. And that's what the federal judge found. He said, fraud is as endemic in hourly petition gathering as it is in paper signature. Because if you're about to get fired because you're not getting any signatures per hour, while you're sitting at Starbucks, you're just going to start forging the bare minimum number of signatures to keep your job. There's no evidence that paper signature is a better inducement for fraud than paper hour. The court threw out all that evidence and said, this is First Amendment, this is pure political speech. This is the most highly protected form of speech we have in our society. And absent a compelling showing by the state that they need this law to prevent fraud, we're not cutting back on the First Amendment.
I'll go a little further. This law was really a lawyer's bonanza because it had more hurdles people had to go through and more ability for someone to challenge it to go over and do legal hassles. I was also a wonderful target of one of those lawyers because part of this law said if your name was on the petition and one of these petition gatherers misrepresented it, somehow for the first time in Colorado history, the guy who's sponsoring the initiative, in that case it was me, would be personally liable for any court costs, which could be hundreds of thousands, even millions of dollars. I mean, after that, other than me, who would ever be stupid enough to put themselves in that situation
again? It had a lot of problems, and the judge said, no, the law is permanently enjoined at this point. The state of Colorado is going to appeal it to the 10th Circuit Court of Appeals, and then they're trying to position this for a review by the U.S. Supreme Court. That's been their espoused goal from the beginning of this whole case.
I've been involved in a lot of lawsuits over a lot of years, and I've seen the state do different things. I don't really remember the state taking on an issue so strongly that was passed through the legislature. I mean, I was there for this thing passed in '09. It's now nearly 4 years later when we have the first major victory of it, and they're still spending taxpayer dollars fighting this. How much have they spent? I mean, they're fighting tooth and nail to keep this law.
It's very interesting because, as you know, that what did I charge you for this, John?
It was a lot. It was a lot. It was more than I usually pay a lawyer. How's that?
Which was zero. All right. This entire case was done on a contingent fee basis, and the beauty of the civil rights statutes it's the Rosa Parks law. If Rosa Parks has to sit in the back of the bus, how much money is an Alabama jury likely to give her if she prevails after a trial and her civil rights were violated? $100 if she's lucky, and that means a lawyer working a contingent fee would get $33.33 for having taken that case to trial. You're not going to find too many lawyers wanting to do it for that. So Congress realized that, and they said, if you prevail in a civil rights case against the government ends up paying your lawyers attorney's fees. So we are, on May 1st, going to be submitting a fee petition to the state of Colorado for all of the time and effort that we've spent litigating this case. So again, I'm sorry to say it, the taxpayers are going to pay my attorney's fees because their legislature passed an unconstitutional law. So sorry about that, taxpayers. Elect better leaders next time.
How rare is it to have this type of victory, to have a federal judge come in and overturn, that is, to permanently enjoin a state law?
It's very rare. I mean,
how rare?
Well, I've been a lawyer for 33 years, and 33 years of being a lawyer, this is the first time that's ever happened to me.
Wow.
And I've been in a lot of cases. But to hold a state statute unconstitutional is a big deal for a federal judge.
I gotta say this, and I mean, your ego is big enough as it is, but damn, man, you were incredible doing this. Now, you and I have some different political philosophies, but to see you in the courtroom working on this on principle, it was really a masterful thing to watch. I was thrilled to be part of it, and it was a long, hairy experience. What do you take away from it all? What did you learn out of this process?
I mean, I've always taken a position, and thank you for your kind words, by the way, but I've always taken a position that, I don't care what your politics are. It's the principle that has to be vindicated. If the Constitution is going to mean anything at all, if the Bill of Rights is going to have any life to it whatsoever, it's people who are on the edge of society, the Jon Caldaras of the world, the Ward Churchills of the world, the people who are pushing the envelope in society, the people who are poking the powers that be, they're the group of people that need the First Amendment. And the government's inclination is constantly to cut it back, cut it back, cut it back. My response is that the First Amendment lives in a very rough neighborhood. And, a lot of people can't stand just how difficult that neighborhood can be. My response to them is they ought to move somewhere where that neighborhood isn't as rough, like North Korea. They don't have those pesky little First Amendment issues in North Korea.
David Lade, thank you. Congratulations. I'm savoring this. I assume that we will be vindicated even if it goes to the Supreme Court. But right now it is a slam dunk victory.
Yeah, I appreciate it. Thank you, John.
Thank you. Stay tuned.